Welcome back to Agriculture Today. This Wednesday morning, we have with us Roger McEowen from the Washburn University School of Law for our bi-monthly segment on ag, law, and taxation. So, Roger, thanks for joining us today.
Good to be with you, Samantha.
We're going to walk through two cases today, Roger. So, the first and foremost, one, a case of tacking, potentially, and then the second one, a case of easement. Both of these came through the Kansas Court of Appeals this year. So let's start with that first one, the first one dealing with tacking.
Yeah, this issue of tacking is several times a year, and what it involves is adverse possession or boundary by acquiescence, and that is when I own my property for a certain amount of time, and I discover that my boundary with my neighbor is not really on the surveyed line. It's, we've been using our properties, our respective tracts, up to a particular area, a particular line. Maybe I have farmed up to that line on my side. My neighbor has farmed up to that line on their side, and we just kind of assumed that that was the boundary. And then, or maybe we have a fence between us, and we just assumed when I bought my property, I assumed that that was on the actual line between the property, and we never really had it surveyed, and that's kind of common in agricultural settings. But at some point in time, a survey is done, and the parties realize that their usage where they treated the line is not really the actual legal surveyed line between the properties. And so then the question comes up, if you haven't owned your property and used it that way for the statutory time frame of 15 years in Kansas, which is the adverse possession statute, can I take the time that I've owned it and used it that way and add on to that my predecessor's time of owning and using the property in that manner? And if that use is consistent, in other words, my predecessor used it the same way that I'm doing, it's possible to add their time to my time to get to that 15-year requirement, and then I can file a quiet title action and have that disputed area quieted title in me.
Sure. So there's a key word here being used in this case specifically, and it's adverse possession. You hinted at it a minute ago, but versus acquiescence. So really, what's the difference between those two terms here that listeners should know?
There is a distinction between two. Often courts, not only in Kansas but elsewhere, will blur the concepts. We get to the same result, but it is a little bit blurry how the courts get there. I cringe every time I read one of these cases because that terminology is not correct. The distinction is this. If I know where a property boundary is at, I know where the legal property boundary is at, and I decide I'm going to use the property on the other side of that boundary. I'm going to use my neighbor's property. That is clearly adverse possession to them. I am adversely possessing their property. I know where the boundary is, and I have with intent and out in the open, I'm adversely possessing their property. I'm farming on it. And the rule is if that person knows that you're in the open, you're adversely hostile to them in terms of your use of their property, and they see it and they don't do anything about it for 15 years, which is the statutory time frame in Kansas, then they can lose that property if you file a quiet, or if I file a quiet title action to quiet title in that area that I'm adversely possessing. And it really, that concept comes from Old England centuries ago, and the terminology is squatters' rights. And so if people would see people coming onto their property and using it, and then they didn't do anything, the common law courts in England centuries ago said, well, you've got to assert your rights, and if you wait too long, you're going to lose it. Well, that property law concept carried over into the United States. So that's adverse possession. Boundary by acquiescence is close to this, but it's just kind of the opposite. That is where we don't really know where the property boundary is at. Nobody's had a survey. We just kind of treat a particular line, maybe a line of trees, maybe a hedgerow, maybe a convenient place to turn a tractor and equipment in a field. And my neighbor and I just treat this common line as the boundary. So we're just assuming that, and lo and behold, it turns out that it's not the boundary. Well, that's a boundary by acquiescence. We just kind of agreed to that. There's no intent to adversely property. But the courts will blur those concepts, and they'll say, well, if a subsequent survey reveals that what you were treating as the boundary is not really the boundary, then whatever party it benefits can file a quiet title action and get the disputed area titled in themselves. So you get the same result. It's just a different concept, one in which where we know where the boundary is. The other one applies when we really don't know where the boundary is.
Very interesting history to those terms, for sure. So we also have, this 15-year requirement that was obviously met here. So the owner or the defendant had possessed the strip of land for 8 years and then claimed that the prior owner before him had it for at least 7. So that met the 15. Is that 15 standard to all states, or is that just to Kansas?
Well, in some states, Kansas is one of the states that has a 15-year requirement. There are other states that have a 15-year requirement, but it's not common in all the states. No, states will vary. In some years, in some states, it can be as little as 2 years. So some states are 7, some are 10, some might be 5. It's just all over the board. Mm-hmm. So 15 is one of the longer statutory timeframes that's out there. I think there's one state or two that's at 20 or 21 years, but 15 is one of the longer timeframes that the states use. So you just have to be aware of what your particular state statute is on that.
Absolutely. So let's get into the second case now, Roger. This one having to do with the removal of vegetation within easement proper. So talk us through this one.
Mm-hmm. Well, this is a case that comes up. It's an issue that irritates a lot of farmers that are along an abandoned railroad that where the rail line has abandoned it, and now a nature conservancy or trail group has taken it over. And that irritates a lot of farmers because the way the rules are at the federal level, the Rail Trails Act, nature group gets an easement, and the landowner really can't do anything about it. Now, there's litigation that has been through the U.S. Supreme Court in years prior in terms of when a railroad abandons a line, does the abandoned line revert back to the adjacent owner? In fee simple, can a group come in and have an easement over the farmer's land to run a trail on that former rail line? And the answer to that depends on state law. It depends on the original property right grant that the railroad received. Did they get an easement? Did they get fee simple title ownership? That's a separate issue. I'm not talking about that one today. But the issue in this case is we have an easement, and so we're not disputing that. What can the nature group do with that easement? And here, what they wanted to do was trim trees and vegetation. And within that easement. Now, they had a 66-foot easement, but they only needed about 10 to 14 feet of width to properly maintain and operate their trail. So here we've got a dispute. You've got a landowner that's got trees that he does not want cut down. He's got other vegetation that he does not want removed. And you've got the trail group saying, well, we've got a 66-foot wide easement. We can do whatever we want within that easement. And so that's how it gets teed up in court.
So for this one specifically, it wasn't a question of do they have the right to take this land, to use this land. It was more of a right of how much do they have access to in terms of their use. Is that correct?
That's right. Yeah. The question was, well, rights with this easement. And again, we're dealing with the scope of the easement. And what I tell people is when you grant easements over your farm property, and we get a lot of these in agriculture. It might be an oil pipeline, it might be an electrical line, it might be some type of utility, and we have these easements. Well, when we draft easements from an attorney standpoint, we want to be pretty clear in the easement language what the easement holder can do. I don't want to grant an easement over my property for somebody to get access to a farm field, mm-hmm. and then they start developing that easement, and it really creates issues for me. So I want to be very specific as to what's allowed and what's not allowed. I want to keep it as narrow as I possibly can, and that's how we can avoid a lot of these problems. Now, in this situation, all you had was the width specified. You didn't really have any language that said what the conservancy could do, what the nature group could do within that 66-foot width. And so that got us a lawsuit because now we're battling over trees and vegetation. And the bottom line on this is the principle that carries in just about all of these cases, and that is it's a rule of reasonable use. And the court came down on that issue. They said, well, yeah, the nature group has the right to trim trees and vegetation. And so the landowner was wrong in saying that they didn't have the right to do that. No, they do. They have an easement. But the Conservancy was wrong, the nature group was wrong in saying that they could do anything they wanted within that 66 feet. And what the court said, and this is the principle that we see repeated over and over, it's a rule of reasonable use. And whatever the nature group needed, the trail group needed to properly operate and maintain that trail, they could clear vegetation, they could clear brush to do so. And the court looked at this and said, you only need to use 10 to 14 feet of the 66 feet. You don't need to go beyond that. And so they struck a middle ground, and it's a middle ground of reasonable use. And that is the rule. When you don't have specific language in an easement, that's the rule the courts will use. It's a rule of reasonable use.
That was Roger McEowen, professor of agricultural law and taxation here at K-State and from the Washburn University School of Law, covering 2 cases from the Kansas Court of Appeals. We'll be back with more ahead here on Agriculture Today.